Hi, my name is Pete Wright, and I'm going to talk about the Doug C. versus Hawaii case. To find the case, go to our website, Wrightslaw.com, and if you just scroll down about a screen or so, here we have a link to the case, and here we have a link to my discussion about it. Or if it's no longer on our main page, if you scroll down the left-hand side, you'll see case law. Click on that link. And we have a discussion about it in the first paragraph here. Or if you go down to the Court of Appeals page, we also have it here in alphabetical order, Doug C., and click on it here. And you can click on it any one of those places, and there is the case. The case is 19 pages long. The plaintiff appellants, Doug C., individually on behalf of his child, Spencer, against the State of Hawaii Department of Ed. In Hawaii, the state runs all the school districts. It is basically the LEA and the SEA. Case was argued October 16, last fall of 2012, and decided on June 13, 2013. And all three judges agreed with the ruling. There was no dissent. So first part of it is a summary of the case, who the attorneys are. Parents represented by Keith Peck of Honolulu. The state was represented by David Louie. This is the actual opinion, and it explains that the plaintiff, the father, Doug C., on behalf of his child, appealed the district court's judgment, finding that the defendant did not deny Spencer FAPE, free appropriate public education. So the district court ruled against the parents. Previously, there was a due process hearing, and the hearing officer ruled against the parents. So the case has to do with an IEP meeting, which changed Spencer's placement from Horizons Academy to a program at Maui High School. The court explained that Spencer was 18 years old, was diagnosed with autism when he was 2, and beginning in the fifth grade, he was placed by the public school, or by the State Department of Education, at Horizons Academy, and there was an IEP meeting on November 9, despite the father's inability to attend, and at that meeting, they changed the placement from Horizons to Maui. The essential issue is whether the department's efforts to include the parent was sufficient to meet the requirements of IDEA. And the child was 15 at the time of the IEP meeting. There were dates agreed upon and then changed because the father was unavailable, and tentatively agreed to a date, but again, tentative, you would have to check. It was scheduled for November 9, but that morning the father emailed the school and explained he was sick and unable to attend, and suggested rescheduling for November 16 or November 17. But the deadline for the annual review was November 13, and some of the staff were not available on the 16th or 17th or on the 12th. Therefore, the school, or actually WAIAU, W-A-I-A-U, who was the director of special ed coordinator at the high school, WAIAU decided to go forward on November 9. He asked 13 people on 3 separate occasions to change their schedules. So WAIAU, apologize for the mispronunciation of the name, and the team held the meeting without the participation of the parent, and the only Horizons Academy staff member was not present. And the IEP team changed the child's placement from Horizons to Maui High School. They sent the parents the new IEP and had a follow-up meeting on December 7 with the parent and the Horizons member present. They reviewed the IEP meeting, and the parent did not have any substantive input at the meeting, and the The father explained that he rejected it in its entirety because he was excluded from the development process and no changes were made to it. However, the day before the meeting, the father filed a request for a due process hearing and arguing that his lack of parental participation denied the child with FAPE. The hearing officer issued a decision finding the department did not deny the child FAPE and dismissed the case. The district court affirmed, holding that the plaintiffs failed to show that the defendant did not fulfill their duty. The court analyzed the legal questions using what's called de novo and analyzed the factual findings looking for clear error. The court explained that harmless procedural errors do not constitute a denial of FAPE. When analyzing whether the school system provided the child with FAPE, there's a two-part inquiry. One is related to procedures, and then the other is related to the facts of the IEP and whether it's reasonably calculated, whether it's appropriate. Yet, harmless procedural errors do not constitute a denial of FAPE. If a court identifies a procedural violation that denied the student with FAPE, the court need not look at the second prong, the factual benefit, the IEP, and whether it's factually beneficial to the child, whether or not the IEP provides educational benefit. Jumping to page 10, the Court of Appeals held that parental participation safeguards are about the most important, and the procedural violations that interfere with parental participation in the IEP formulation process undermines the very essence of IDEA. On page 11, the court explained that a meeting may only be conducted without a parent if the public agency is unable to convince the parents that they should attend. But there must be detailed record of the attempts to include the parent. The court explained that the parent did not affirmatively refuse to attend, nor could it be said the department was unable to convince him to attend. Despite that, the department went forward with the IEP meeting without him and then changed the placement for the first time in 6 years. They explained that it was frustrating to work with the parent, but the court said, we have consistently held that an agency cannot eschew its affirmative duties by blaming the parents. An agency cannot blame a parent for its failure to ensure meaningful procedural compliance with IDEA because the protections are designed to benefit the student. Because the department's obligation is owed to the child, any alleged obstinance of the parent does not excuse the department's failure to fulfill its affirmative obligation to include the parent in the IEP meeting. And they explained that they had to hold it on that day because of the November 13 deadline, and also explained that did not want to disrupt the schedules of the other IEP team members. But the court explained that the attendance of the parent must take priority over the other members' attendance. By refusing to reschedule the meeting for Thursday or Friday, the special ed coordinator improperly prioritized the schedules of the other members of the team over the attendance of the parent. On page 14, the special ed coordinator testified, and also the Department of School Board council attorney represented oral argument that if the deadline passed without a new IEP, services would lapse. And the district court said the same thing. The Ninth Circuit has said that is premised on an erroneous assumption that services to the child will cease if the annual IEP is overdue. There's no authority for the lapse or termination of services because the IEP has passed the timeline. They made that clear in this sentence. If you have two distinct procedural requirements and they are seemingly at odds with each other, then how do you analyze it? The court said you have to look at the purpose of the law to provide the child with FAPE and to protect the educational rights of the students. There must be a determination of which course of action promotes the purpose of Individuals with Disabilities Education Act and least likely to result in denial of FAPE. At the same time, there's reasonable latitude. And the court explained that the department had two options: include the parent in the meeting and miss the deadline by several days, or proceeding with the meeting without the parent but meeting the deadline. In that instance, parental participation trumps the timeline. Delays in meeting IEP deadlines do not deny a student FAPE if they do not deprive the child of educational benefit. The department's decision to prioritize strict deadline compliance over parental participation was clearly not reasonable. Page 16, Hawaii argued there was no violation because of the December 7 IEP meeting, and the court said that per an earlier decision called Shapiro, after the fact meeting did not remedy the initial IEP meeting without the parent. Page 17, last paragraph, the court wrapping up explained that because the parent's opportunity to participate was seriously infringed and that procedural violation denied the child an educational opportunity by causing the merits of his placement horizon to receive insufficient consideration, the department denied Spencer FAPE. Page 18, the court explained they reversed the district court judgment and on remand must determine whether Doug C. is entitled to reimbursement for maintaining the child at Horizons during the legal proceedings. And that concludes the discussion of this case. Thank you.